I'll read out the essence of the judgment. There are three judgments of this court. One authored by the Chief Justice for himself, Justice Gavai and Justice Surya Kant. There is a concurring opinion authored by Justice Sanjay Kishan Kaul. Justice Sanjeev Khanna has concurred with both the judgments. The reference before the Constitution bench raises the following questions for determination. A, whether the provisions of Article 370 were temporary in nature or whether they acquired a status. I'll read out the essence of the judgment. There are three judgments of this court. One authored by the Chief Justice for himself, Justice Gavai and Justice Surya Kant. There is a concurring opinion authored by Justice Sanjay Kishan Kaul. Justice Sanjeev Khanna has concurred with both the judgments. The reference before the Constitution bench raises the following questions for determination. A, whether the provisions of Article 370 were temporary in nature or whether they acquired a status permanence in the Constitution. B, whether the amendment to Article 367 and exercise of the power under Article 371D was to substitute the reference to the Constituent Assembly of the state referred to in Clause 3 of Article 370 by the words Legislative Assembly of the state is constitutionally valid. C, whether the entire Constitution of India could have been applied to the state of Jammu and Kashmir in exercise of the power under Article 370, Clause 1, bracket D. D, whether the abrogation of Article 370 by the President in exercise of the power under Article 370, Clause 3 is constitutionally invalid in the absence of a recommendation of the Constituent Assembly of the state of Jammu and Kashmir as mandated by the proviso to Clause 3. E, whether the proclamation of the Governor dated 20 June 2018 an exercise of power conferred by Section 92 of the Constitution of Jammu and Kashmir and the subsequent exercise of power on 21 November 2018 under Section 53(2) of the Constitution of Jammu and Kashmir to dissolve the Legislative Assembly are constitutionally valid. F, whether the proclamation which was issued by the President of India under Article 356 of the Constitution on 19 December 2018 and the subsequent extensions are constitutionally valid. G, whether the Jammu and Kashmir Reorganization Act 2019, by which the state of Jammu and Kashmir was bifurcated into two union territories, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh, is constitutionally valid, bearing in mind, 1, the first proviso to Article 3, which requires that a bill affecting the area, boundaries, or name of a state has to be referred to the legislature of the state for its views. And 2, the second proviso to Article 3, which requires the consent of the state legislature for increasing or diminishing the area of the state of Jammu and Kashmir, or altering the name of the boundary of the state before the introduction of the bill in Parliament. H, whether during the tenure of a proclamation under Article 356, and when the Legislative Assembly of the state is either dissolved or is in suspended animation, the status of the state of Jammu and Kashmir as a state under Article 1(3)(a) of the Constitution and its conversion into a union territory under Article 1(3)(b) constitutes a valid exercise of power. I'll now read out our conclusions under different heads. Whether the proclamation issued under Article 356 of the Constitution of India and Section 92 of the Constitution of Jammu and Kashmir is constitutionally valid. We have held that this court need not adjudicate on the validity of the proclamations because, 1, the pleadings of the petitioners in the writ petitions indicate that their principal challenge is to the abrogation of Article 370 and whether such an action could have been taken during Precedent's rule. And 2, even if this court holds that the proclamation could not have been issued under Article 356, there would be no material relief which can be given in view of the fact that Precedent's rule was revoked in the state of Jammu and Kashmir on 31st October 2019. Further, the petitioners have assailed the specific actions which were taken when the proclamation was in force on the ground that those actions breached the constitutional limitations on the exercise of power after a proclamation under Article 356 is issued. These substantive challenges, which form the fulcrum of the case of the petitioners, have been considered. Next issue, whether there are limitations on the exercise of power by the President or Parliament under Article 356. We have held that there are limitations on the power which can be exercised by the union government in the state when a proclamation under Article 356 is in operation. We have reached the conclusion on the following grounds. A. The majority in S.R. Bommai, the 9-judge bench decision, held that the actions taken by the President after issuing a proclamation are subject to judicial review. However, the learned judges adopted slight variations on the standard needed to be applied by the court to test the validity of the exercise of power by the President after the issuance of the proclamation. Justice Sawant applied the standard of whether the exercise of power was mala fide or palpably irrational. Justice Reddy observed that the advisability and necessity of the action must be borne in mind by the President. 2. This bench, sitting in a combination of 5 judges, is bound by the decision of the majority in S.R. Bommai on the issue. We also undertook a textual and purposive reading of Article 356 in particular and Part 18 as a whole. We hold that there are limitations on the power exercisable after a proclamation under Article 356 is issued. The following are our reasons. First, the thread that runs through Part 18 of the Constitution, when read as a whole, is that differing levels of executive and legislative power are required to handle an emergency under Article 352 and under Article 356. This principle applies to the exercise of power when a proclamation under Article 356 is in force. Second, Article 356(1) states that the President may, by a proclamation, assume or declare the powers stipulated in clauses A, B, and C of Article 356(1). The powers stipulated in clauses A, B, and C of Article 356(1) are not automatically invoked when a proclamation is issued under Article 356. Third, Article 356(1)(a) does not opt for an all or none formula. The phrase all or any does not indicate that the union government can exercise a part of the functions of the state government and the state government can exercise the remaining, because the suspension of the state government is an automatic consequence of the proclamation under Article 356. It rather indicates that the scope of the power exercised by the union government must depend on the circumstances for issuing the proclamation. Fourth, clauses A, B, and C of Article 356(1) grant the President independent powers. However, the power provided under Clause C is broad enough to encapsulate the power of the President to assume functions under Clause A and declare under Clause B that the powers of the legislature of the state shall be exercisable by Parliament. Fifth, the principle underlying Article 356(1)(c) is that the exercise of power by the President must be desirable or necessary to give effect to the objects of the proclamation. The commonality in both the necessity and desirability standard is that the exercise of power must have a reasonable nexus with the object of the proclamation. Thus, the principle which runs through Article 356(1)(c) and which also guides the exercise of power under Article 356(1)(a) is that the exercise of power must have a reasonable nexus with the object of the proclamation. And sixth, when a proclamation under Article 356 is in force, there are innumerable decisions which are taken by the union government on behalf of the state government for the purpose of day-to-day administration. Every decision and action taken by the union executive on behalf of the state is not subject to challenge. Opening up challenge to every decision would lead to chaos and uncertainty. It would in effect put the administration in the state at a standstill. Therefore, the following standard is laid down to assess actions under Article 356 after the proclamation has been issued. A. The exercise of power by the President under Article 356 must have a reasonable nexus to the object of the proclamation. B. The person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. After a prima facie case is made, the onus shifts to the union to justify that the exercise of power had a reasonable nexus with the object of the proclamation. And C, the exercise of power by the President for everyday administration of the state is not ordinarily subject to judicial review. The argument of the petitioners that the union government cannot take actions which have irreversible consequences when a proclamation under Article 356 is in force is not accepted. The power of the legislature of the state under Article 357 to repeal or alter or amend a law enacted by Parliament in exercise of the power of the legislature of the state must be read in the context of the amendment introduced by the Constitution, 42nd Amendment Act 1976. Before the amendment, the law to the extent of incompetency would automatically cease to exist after a buffer period and actions done were expressly saved. However, an express repeal by the competent legislature is required for the law to cease to exist after the amendment. The repealing statute would, in such case, make provisions for actions taken during the subsistence of the legislation. The observations in Krishna Kumar Singh on whether the consequence of an ordinance can subsist even after the ordinance ceases to exist cannot be transposed to interpret the limits of Article 356 because an ordinance which has the effect of a law by its very nature has a limited life. The argument of the petitioners that Parliament can only assume the lawmaking powers of the legislature of the state when the proclamation under Article 356 is issued is not accepted. The purpose of Article 357 is to ensure that while exercising the powers of the legislature of the state, pursuant to a declaration under Article 356(1), Parliament, or as the case may be, the President, are not impeded by an absence of competence, which would have impeded the exercise of a similar power in the absence of a proclamation under Article 356. Further, Article 357 does not contain a non obstante provision which overrides Article 356. To interpret Article 357(1) as a restriction on Article 356(1)(b would be to read in a restriction which the plain terms of the Constitution do not provide. As held above, the exercise of power after a proclamation under Article 356 is issued is subject to judicial review, and immunity from judicial scrutiny does not attach to the exercise of constitutional powers of the legislature of the state.